Afternoon, everyone.
Hey,
If you can,
I'm not getting any audio.
good afternoon, everyone. This is Al Tariq
Huh?
Kinney.
Yeah, but I can't
Okay.
hear you. That ain't gonna work.
So, good afternoon, everyone. My name is Al Tariq Kinney, and I currently serve as your Essex County Surrogate. I'm going to give you a couple of seconds, if you don't mind. Not only can you log in, but if you can share the information on your page, that'll be helpful for this conversation as we present today. So we're going to give a couple of more seconds. We have a very, very important conversation that we are going to be discussing. So we have one more gentleman that will be joining us. His name is Professor Charles Affont. And also, we just lost our deputy surrogate, who should be logging in a second. First, let me tell you who we are, and also give you some more time to share information on your page if you don't mind. Um, my name is Alter Kinney again. Serve as the current Essex County Surrogate in the County of Essex, and so we want to have a important conversation about adult guardianship. And so we have some very, very important people who will be providing you information. But this conversation is the conversation. Please, if you have any questions, ask those questions um, in the stream so we can make sure that our experts in this space are able to answer your question in real time and provide you some information as to what we do and give you some direction now how important this topic is. But let me just give you some facts before I introduce. In fact, you know what? I'm gonna do the opposite. Let me introduce the our guest. Um, right now we have Tara Wilson, who is a proud graduate of Westside High School. I just saw that our former councilman Ron Rice has got online. So this is one of your own. Tara Wilson is a proud graduate, Westside High School Rough Rider, and attended William Patterson. And she is our Superior Court clerk. She's been working in this space for the last 15, 16 years. Can you please let people know who you are, Tara?
Hello, 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 everyone. I'm Tara Wilson, and I handle all your guardianship matters here. And this is the perfect time to be discussing such manners and matters because it is Mental Health Awareness Month. And I hope this discussion helps guide everyone accordingly.
Got it. Again, back again is one of the smartest men in this space, who is a science high school charger, but also a Rutgers graduate, law school, and CPA. He serves as our deputy surrogate, Devera McDougall.
Hello, everyone. I would like to give my appreciation to everybody here at the Essex County Surrogates Court. The courts aren't closed, and so our people have been coming in. It's a modified schedule, but they've been coming in 8:30 to 1 to still provide the services that are needed to our constituents. Given the state that we're in with the pandemic, we know that our services are definitely going to be, unfortunately, needed more than in the past. But as Tara said, this is an appropriate time to do this, given that this is the this is health mental health awareness month. The other thing I wanted to point out that this does tie into all our conversations in the past, because this is part of estate planning. If estate planning doesn't work, you're going to have to go through this process to become appointed guardian. And I just want to make an apology for Charles Affont. He's trying to get on. He's having some computer problems, so hopefully he'll be on in the next few minutes. You took it off, right? You put it on mute.
Good. So great. So let me just get CDC. One of four adults, which means 61 million Americans have a disability. That disability can go into 6 different regions: mobility, cognition, hearing, vision, independent living, and self-care. And 24% of the residents in this country suffer from two of the most recognizable, which is mobility and cognition. And two in five adults who are over the age of 65 years old, unfortunately, will suffer from a disability. And so this give you context as to why this conversation is important, because disability is reality in a number of people in our lives, whether it's, our parents, grandparents, our children, someone that we love the most, a friend, a neighbor, a cousin, someone may come down with a disability where they need someone to step in and help them manage their affairs. And so, Tara, you've been in this space for the last 16 years. You're an expert in this space. Everyone who is applying to be a guardian comes through your pathway. Can you please tell people what is adult guardianship? Tell them what that is, and provide some information as to what that means.
Yes. Adult guardianship is being appointed a guardian for an adult who's unable to make decisions sound-mindedly for themselves, financially, medically, residentially. It's all different types of guardianships as well for adults, but the what we mainly focus on are incapacitated adults.
So let me add to what Tara just provided. So in the state of New Jersey, each individual is deemed to be able to care for themselves and their affairs once they reach the age of majority. And the age of majority in New Jersey is 18. And so what happens when somebody, whether it's a child who has developmental disabilities or a parent, grandparent, or relative who loses their ability to care for themselves, a court case has to take place. So it's a legal process. So adult guardianship is a legal process that occurs. And so in that process, it's a two-pronged process. First, a person has to be declared incapacitated. And the second part of that process is a guardian has to be appointed. And the judge does that. And the judge that does that is a Superior Court, Chancery Division, Probate Part judge. Our role, we work with the Surrogate Court. The Surrogate Court, we are the Surrogate Court. The Surrogate Courts work with the Probate Part judge to handle that. And so if you don't mind, I'd like Tara to explain our general role as a Surrogate Court in that process.
Yes. We initiate the process by processing the required forms, making sure all is sufficient for me to submit to the Superior Court judge, to have a court-appointed attorney get involved and set the case to be heard, in which the judge will have a hearing and appoint a guardian. And then I will qualify and issue letters of guardianship.
And so with that,
Thank you, Tara. There's a couple of questions that came in.
Before you ask the question, in a nutshell, we are basically managing the cases for the Superior Court, and we are the keeper of the records in our role as the deputy clerk. And so that's why Tara initially get the paperwork and process, because our role is to work with the Superior Court as the deputy clerk and to manage it.
Calling DeVero McDougal.
We hear you. You don't have to call me. Yes.
So,
can you hear us?
So we actually we have. We have Charles Afant that's on. We have Charles Afant that's online. I'm going ahead and introduce him real quick. Charles Afant is a scholar. He's been in this space for several years. He's the Rutgers Law School clinic He's at the Rutgers Law School Clinic. Just please let us know who you are, Charles, and introduce yourself, please. Charles,
Don't.
professor.
All right. Don't hang up on me.
Professor, you might want to unmute your phone. Yes. Just let us know who you are and give us a little sense of who you are and your background. But your it's muted.
We can't hear you.
Yeah.
Can you hear me now?
Yeah.
So we can hear you now. I think we hear you now. So,
Okay. So
yes, we can. Go ahead.
my name is Charles Offon. You can hear me, but I can't hear you. So we'll have to use hand signs. If I keep my phone on, I get an echo. My name's Charles Offon. I'm a clinical professor of law at Rutgers Law School, the People's Law School of the state of New Jersey. And the Surrogate's office, starting several years ago, approached the clinic that I work in and asked if we being my law students, our clinic, if we would represent persons against whom petitions of incompetency had been filed. And we've been doing that for several years now. I think we've been providing a great service to the people of Essex County through the Office of the Surrogate. Should we start talking about the process of guardianship?
So Tarek gave a general explanation. So I think what we would like to do is kind of give a couple of fact patterns and to walk people through it. Then that way, I think people have a better understanding of how to approach adult guardianship. Would that work for you?
Yes.
Okay, so what we'll do is let's give you the first scenario. So, and I'll use myself as an example. So I have a 17-year-old daughter who is getting ready to turn 18, let's say in November. She is developmentally disabled. And I also have my wife, a 20-year-old daughter, 13-year-old son that lives with me. And she attends school for special needs. And so I want to continue to care for her when she turns 18. As I explained to the people in New Jersey, when you turn 18, that's the age of majority, and you're deemed, and it's a presumption, a rebuttable presumption that you can care for yourself and your affairs. So if I were to come to you, you were my attorney, what would be the first process? Let's start of the process.
So I'm going to try not to be too much of an academic, but cut me off if I start going too far abroad. As you noted, in New Jersey, when you're 18, you're presumed by the law to be a competent adult and able to make all decisions of your own. So mom and dad, who may have made decisions for you in the past, no longer have that legal authority to do so. And that authority can only be changed from the young person who has just turned 18 back to parents, one or both. Here, there's a mom, I think you said in your your hypo. It can only be given back to mom by order of the court. And there's a process to do that. And although it is seen by many as a somewhat burdensome process, I think what we have to remember here is what we're asking the court to do is a very important thing. We're asking the court to take away someone's civil rights. We're asking the court to deprive a person of the ability to make choices for themselves, where they want to live, where they want to go to school, where they want to work, who they want their doctor to be. All the decisions that we take for granted are given back to, here in this hypothetical, mom, even though the child is now an adult. That's a lot to ask a court to do, and a court looks very seriously at that. If you came to me, we would have a long talk. I'd want to hear the history of the child. Did this child go to special education classes? Were they identified by a child study team? When? When was the last time the child study team prepared an individual education plan? I'd want a copy of that. The general rule under the law is that in order to proceed with this petition and file it with the surrogates court, I need 2 doctors to fill out certifications that say that this young person here cannot take care of their own finances or their own affairs. There are various there are various documents that have to be filled out by the attorney, since there is an attorney in this hypothetical. And that entire packet has to then be filed with the surrogates court. The most important thing is the doctor's certifications. And those doctor certifications have to be based on examinations by the doctor, which occur within 30 days of the petition being filed. I have to advise a history. I have to give the 2 doctor certs, or in this case, if there is an IEP, I could give 1 doctor cert and the IEP.
And what's the
I
IEP?
also need a certification filed by someone in the with the Division of Developmental Disabilities, saying that this young person has been deemed eligible for services. It's a serious process, and I would hope that mom here has started it a little before the 18th birthday, so that the process can be started and there won't be a big lag time. Let me stop there and listen if you have any questions.
The question was asked, what is an IEP?
So an IEP is, and forgive me for falling into the legal speak. Thanks for shaking me out of it. An IEP is short for Individual Education Program. If your child is been deemed eligible for special education services, they have to be seen by a team, a child study team, and that team has to determine how we can give this child an appropriate education. What additional services are needed to educate this child properly? And after the team reviews the child and tests the child, this program is made up that specifically is geared to that one child, what services that child needs. It also is based on the examination of the child by at least 3 child study team members. And who are those members? One is a sociologist, one is a learning disabilities teacher consultant, and the other is the school child psychologist. They put a report together. They based on their testing. It gives the court a significant amount of information. That's what an IEP is.
Thank you. So, would you recommend that a parent who has a child of approaching age of 18 years old pursue this before they become 18?
Yeah, I think that it's important to start this before the child turns 18 because as this current nightmare shows us, none of us know what tomorrow brings. And once that child is 18, mom can no longer have the legal authority to make decisions. So if an emergency medical procedure is required, mom no longer has the power to sign. Important things like that can only be done if you have the legal authority to do it. And once your child turns 18, mom loses that legal authority.
So I just want to say to T. Leah Bowers, we're going to give another scenario with somebody over the age of 18. So just hold on, and we'll give a scenario that will answer your question. And I know Miss Kalina, I'm sorry if I said that wrong, asked if the youth is already DDD eligible. Is that what the parents present in guardianship filing? And I want to allow Tara to ask that because that is a substitute that can be used.
Yes, yes, yes. A DDD representative can fill out one of the certifications in place of a doctor certification, and it will be acceptable as part of the required doctor certifications or certifications by a DDD representative to be submitted with your filing.
And if you can just let everybody listening know what DDD stands for.
DDD is the Division of Developmental Disabilities.
Thank you.
Mm-hmm.
Thank you very much.
The surrogate is keeping us on our
So,
toes.
because I know you guys are smart, we don't want to continue using words that a lot of us may not understand. So let's go to Tila Bowers' question. What is the process if the adult is 40 years old and has been in and out of the mental holds at local hospitals, but has not been officially diagnosed because the adult does not do a follow with a mental health doctor?
So, let me lower this. This is not an unusual occurrence.
Mm-hmm.
The law requires the same whether you're 18 years old or 40 years old. You have to file several documents with the surrogate's office, a petition for guardianship. You need those two certifications from doctors. And there are some other documents. All the financial information of that person has to be disclosed because if the person is determined to be incapacitated, technically they become wards of the court, and the court becomes responsible to ensure their well-being. One of the first things the court does is appoint a guardian to care for that person. That guardian, however, is appointed with responsibilities to the court. They have to report to the court at least yearly on the health and finances of the guardian. Where is the money that the guardian gets for that incapacitated person? Where does that come from? How is it being used? Because that's not the guardian's money, and often it's Social Security. It's the incapacitated person's finances. What about the health? You have to report on the health. It's a report that has to be filed yearly with the surrogate. So if the person's 40 years old, has been in and out of institutions, the same process has to be followed. But let's say the person refuses to go to follow-ups, like Ms. Bowers suggests. You could file a petition with the surrogate, and the surrogate can assist you in filing, I believe it would have to be an order to show cause, to have the court order this person to submit themselves to an examination by a physician, two physicians here. And that, once that order was signed by the court, that person would have to submit to an examination by a physician, two physicians, and ultimately the court has power to enforce that order. Hopefully that doesn't have to be done, but it is a tool that the court does have and can use to force examinations so that the guardianship process, the process of determining whether a person is incapacitated or not, can proceed. I hope that answers your question.
Mhm. Great answer, Professor.
Sure.
So let me
So, what is the background?
let
Let
me
me ask one question. 'Cause
okay.
just want to follow up question because maybe it can provide some clarification. What is like? How do you become a guardian? Like, what's the minimum requirements
But
to be a guardian?
before you answer that, I want to take a step back. So in the process to come, so we went. He's the attorney. He came in. So there's a couple of things he needs to determine before we get to that. How do you know which surrogate court to file this in, and who has the ability to file this case in surrogate court besides, let's say, a parent? So I want to get those out the way first because those are important to come first before the guardian is even appointed.
Okay. So there is a thing in the law we call jurisdiction. Courts, in order to have power, have to have jurisdiction. And there's two kinds of jurisdictions. There's jurisdiction over the subject matter. Here it's guardianship. Not every court has jurisdiction over that. The surrogate's court has primary jurisdiction, and it shares that with the Superior Court Chancery Division. So that's who has subject matter jurisdiction. That's the court where this must be filed. Must be filed with the surrogate, and the matter will be heard in the Superior Court Chancery Division. That's subject matter jurisdiction. The next is venue. Let's talk venue. And venue is, now we know New Jersey has the power here if the person is domiciled in New Jersey and has been domiciled in New Jersey for some time. Off the top of my head, I forget what the minimum amount of time is, but let's say it's 90 days or a year. Then New Jersey has the power to determine this. And we're talking about whether the person is incapacitated or not. Where does that incapacitated person reside? Where are they domiciled? If they live with their parent, here, mom, in Essex County, but happen to be in a hospital in Middlesex County, well, they're still domiciled. Their primary residence is in Essex County. So that case must be filed in Essex County. So jurisdiction, which court has the power to hear it? That's easy. If as long as they're citizens of New Jersey, it's the surrogates the surrogates court, and the Chancery Division of the Superior Court. And what county is that person domiciled in? Because our court's venue is determined by county. If they're domiciled, the place where they live, their primary residence is in Essex County, that's where the case has to be filed. The Surrogates Court of Essex County.
Okay, and so in this scenario, we said mom. So is anybody other than mom able to have standing to file the suit?
Right. So who has the power to file? Well, not a simple question, because it really goes to a thing we call in the law called standing. Who has the power to bring an action to the court? Well, clearly, in our hypothetical, this is a single mom. This is her child. Mom has that power. Dad would have that power. Here, it's a bit different. The court will recognize people who are not relatives. Now, relatives, and the closer they are, the better they can argue that they have an interest standing. But let's say that there's no family. Who takes care of persons with no family? Well, a friend could file in that case. And the surrogate's office has allowed persons who are friends to file these cases. The court may look at that more closely, and there's a process that I think we'll get to, but the surrogate will allow that to go through if it meets the requirements that they look at, and I'm sure they'll speak to that. There's also a quasi-governmental agency, and I'm not going to make the surrogate upset by using just the short name, APS. It stands for Adult Protective Services. This agency, quasi-governmental agency, is charged with detecting and preventing fraud and or abuse in our elderly population, a population I am part of now. And they have no relationship to the elders that they look out for, but they, if someone calls them and says, you know, I think they're taking advantage of old Charlie Offant. They're coming in and taking his food. APS will send someone out to do an investigation, and they'll assess the matter, and they'll assist. Maybe the assistance will be just setting up a home health care worker. Often, however, they might determine we need some doctors to come in. They have doctors to test the person, and they'll determine whether they should bring an action requesting the court to say that someone is incapacitated. So who can bring these actions? Preferably family, but any interested person can initiate the process. And that could be a friend or a neighbor.
There was a question asked, can guardianship be transferred from state to state?
I'm sorry, one more time? Once?
The question was, can guardianship be transferred from state to state?
That's a great question. Once a guardianship has been granted by the court, I mentioned earlier that the guardian, the incapacitated person, becomes a ward of the court. And courts are specific as to states.
Yeah.
One of the things that the guardian must do is the guardian must advise the court when they are going to move or that incapacitated person out of, for us, Essex County, for more than 10 days. Now, you can go on vacation. That's not what the court's talking about. But if you want to move to Middlesex County, you have to advise the court. And that will be allowed. But your court, but that case remains open, and it remains open in Essex County. It's a little bit different. Any other case would probably be eligible to be transferred to the new county. Here, once that guardianship is opened in Essex and that person becomes a ward of the court in Essex County and the surrogate's office in Essex County, that case stays in Essex County. But that's not the question. That's not the answer to your question. Let's say.
Thank you. There was a question.
You want to
No,
move
he's not finished. He's
to.
not finished.
Excuse me.
Keep going.
Okay.
Yeah. Let's say you want to move. You've had. Mom has had her child declared an incapacitated person in Essex County, and she wants to move back to her childhood home of North Carolina. Well, we have what's called interstate compacts. We recognize that we have to have some similarity in some laws from state to state. So we have an interstate compact, and that's required the states to adopt a similar statute that adopts a procedure to transfer a case like this, a guardianship case, from New Jersey to North Carolina. Again, it's a bit cumbersome. And the reason why it's cumbersome is this is a ward of the court. The court in New Jersey or any other state wants to make sure that that person is going to be registered as a ward of the court in the new state and that they're accepted as such. So, in order to do that, you have to open a case in the new state you want to move to. And when that case is open, you'll get an order saying we've opened the case and we're willing to take the transfer of this guardianship. And once the New Jersey court gets that, they'll transfer the court to the new state. And that's how that's done.
Thank you. Question, is anxiety a disability? And if so, is it easily possible to obtain guardianship over someone who constantly demonstrates this behavior?
I'm sorry, could you just repeat that one more time? I had to turn up my phone.
Don't worry about it. Question, this is from Ms. Kettles, is anxiety a disorder? And if so, is it easily possible to obtain guardianship over someone who constantly demonstrate this behavior?
So, as I said earlier, guardianship has two parts of that case, right? The first part is this person incapacitated? Are they unable to control themselves or their affairs? And then, if so, who will be appointed guardian for them? So, is anxiety a disability that can cause someone to be declared incapacitated? Look, there is no matrix or easy answer. I can't answer that question. It might be. It depends on the facts of the case. And that's the thing about our system. We have a system that's fact-based. Every case is different, and the facts of that case are viewed in their entirety. It would depend on the doctor's reports. Now, here's an important other point about these cases. When you take, as I said, taking someone's civil rights away is a serious thing for a court to do, and courts don't do that lightly. The law doesn't do that lightly, and this is the process that's set up. Once your petition and all accompanying documents are approved and they're sent to the surrogate's office, and let's assume that the surrogate's office passes them on to the court, something, a process is started. The court appoints an independent lawyer to represent the alleged incapacitated person. Let me repeat that. The court gets this document that the surrogate says, okay, all the documents are here, we're prepared to have a hearing in this matter. The court then appoints an independent lawyer to represent the alleged incapacitated person. Now, that lawyer doesn't work for the person who wants to be guardian, doesn't work for the court, doesn't work for the surrogate's court or the superior court. That lawyer works only for the alleged incapacitated person. And the rules governing lawyers, as well as court cases, say that that lawyer works at the direction of the client. So if that person, if I'm the lawyer that's appointed, and this has happened, if that person tells me, I don't want to have a guardian, well, then I have to do what they request, unless it is patently absurd. So if it's not patently absurd, I then have to resist the imposition of a guardian. And what does that mean? That means I may get my own doctors to refute the doctors that made the initial certification. This can go for a hearing where I'll get to cross-examine those doctors. They'll have to put those doctors on. And although I haven't had this pleasure yet, this court, Chancery Court, the general rule is there are no jury trials in the Chancery Division of the Superior Court, except in a few circumstances. And here, you can ask for a jury trial. So it is not easy. The person against whom guardianship is sought can resist it, and often does. And sometimes guardianship is not authorized by the court based on this conflict that plays out in the court.
So, Tara, can you do me a favor? I want you to answer a couple of questions, specifically the types of guardianships that is available to a person, and provide some clarity, because there are different types of guardianships, correct?
Yes, that's a great question. Guardianship is broadly separated in two parts. Guardianship of the person. That means you'll have power over that person, where they live, who their doctors are, where they go to school. All of the things that that person could otherwise decide for themselves would be transferred to the guardian of the person. There's also, the other part of that is the guardian of the property. Sometimes incapacitated persons have property. Sometimes it's a Social Security disability check or SSI check. Sometimes they own homes and stocks and bonds. So a person could be guardian just of the property. Maybe the person is wasting their money, but otherwise can take care of themselves. The court can appoint someone either just guardian of the person or just guardian of the property, or can appoint a plenary guardianship and that gives a person power over the alleged incapacitated person and property.
Mhm.
Also, in New Jersey, we have a thing called limited guardianship. Maybe there are some areas that the alleged incapacitated person is fine with. Maybe they can decide who they want to marry. Maybe they should be able to decide where they want to work or where they want to live. Um, it's important, and the law in New Jersey wants to give as much power over decision making as possible to the alleged incapacitated person. So New Jersey does allow limited guardianships. Um, those are the different types of guardianships available.
So let me do a quick response to a couple of questions.
I
We'll
think
follow back up with the anxiety question, but also addiction. So whether anxiety is something that would be deemed to be um, something that cause somebody incapacitated or a drug addiction or alcoholism, that's going to be dependent on whether or not you get a doctor certification to indicate that. And the judge is going to weigh heavily on what the doctor says. The doctor certification will be what the judge determines. Simply having anxiety by itself is probably not going to be sufficient enough. That anxiety has to be so that that individual is no longer able to care for themselves and their affairs. The same with the drug addiction or the alcoholism. So I just want to follow back up on those questions that they a couple people asked. I think it was Kalina that asked that question as well.
yes. Tara, process. Explain from. I'm sorry. From the superior as the superior court side of it, can you please explain the process that someone has to go through for the guardianship process?
Yes. Again, as Professor was explaining, the required forms needed to start the process is submitted to me here at the Surrogate's Court. And you can seek counsel or legal services and or proceed pro se, where we have courtesy packets of the pro se required forms, and or you can download the required forms, which includes the doctor certifications, from the njcourts.gov website, and it's also a link on our page. And in this packet has all the required forms to proceed and submit to me for the initial process of the application for applying for guardianship.
And what is the fee for that, Tara?
There is a required fee of $200 payable to the Essex County Surrogate by way of, check or money order. And or you can submit a filing fee waiver, and the judge can consider it based on the required information as well that you submit with the fee waiver, for the judge to consider and granting if the fee can be waived or not. And then both can be downloaded from the njcourts.gov website and or from a link on our Essex Surrogate page. And or submit it from me. I could courtesy copy. I could send out the courtesy copies I have here.
And we can also add this link to this conversation as well. So it can be, we have multiple ways to provide that information. I want to ask a question. There was a question that came in by Yolanda Johnson about where can you get the interstate packet?
So
Interstate?
There's not an interest. What the professor was saying was there's an agreement between states to respect the wishes of the other court and have a conversation with each other to allow for the transfer. The only packet there is what Tara was talking about we're going to provide the link and part of the comments, is that if anybody wants to do this on their own, be a pro se litigant, that packet would allow you to do that. It has wonderful instructions. It has all the forms that the professor was talking about, doctor certifications, or if you want to use the IEP instead of one of the doctor certifications, or the letter, a letter from DDD. Those things are in the packet. It's a wonderful packet that explains it. So that's the only packet we have. But like I said, what the professor was talking about, there's a compact between, basically we're saying a compact agreement between states to honor decisions in one state and to transfer the case. They have to talk to each other. One state has to agree to take it. The other state has the other court, I should say, the other court in that state has to agree to transfer the case. So that's what he meant by the interstate packet.
Thank you.
Okay.
There was a question that while we were organizing this conversation, there was a question that was brought up about the difference and what is more preferred between pursuing a guardianship or power of attorney. What is the difference? What gives that a family member more access, more power, more ability to have direct control over that person's care? Power of attorney or guardianship, or adult guardianship?
Good question. Let me lower my volume on my phone. There are different types of powers of attorney. And a standard power of attorney ends when someone becomes incapacitated. So if you have a power of attorney and someone goes into a coma in a hospital, that power of attorney may cease to give you power to act on that person's behalf. A power of attorney can also be limited. It's a voluntary document, and I can give my Mr. McDougall power of attorney to act for me only as for my banking. That doesn't give him power to make medical decisions for me. If I get ill and I become disabled, that power of attorney, the standard power of attorney, will cease to have effect. There's another power of attorney called a durable power of attorney. A durable power of attorney is durable because even if one becomes disabled, it doesn't terminate that power of attorney. And if someone has a durable power of attorney, if someone has my durable power of attorney and I become disabled, I may not need to have a guardian appointed for me because that person who has that durable power of attorney, if it encompasses both everything that requires my person and my finances, they have power to act for me in all instances. There's another type of attorney, power of attorney called a springing power of attorney. This is a power of attorney that only takes effect if I become disabled. Sounds like a great idea. Often, banks, for instance, may be wary of accepting it because unless they know I'm disabled, they might be wary to give someone who has that power. So I've heard some attorneys say often that just brings problems. But one of the things you can do is called estate planning. You don't have to wait until you're disabled to put a plan in place. And I know, Surrogate, you've been working around Essex County with your team to bring this notice to people. If you have a will, if you have what's often called a living will or advanced directive, and a durable power of attorney, you may not need to worry about someone in your family having to bring an action to become your if you should become disabled. The durable power of attorney can give people power to act in all areas of your life,
Mhm.
medical, financial. Uh, the advance directive will appoint someone to make healthcare decisions if and when you're unable to do so, and will let that person know what choices you have. So if you don't want to be on a ventilator, you can say that. If you do want to be on a ventilator, you can say that. You can leave instructions for that person so that they can follow your wishes that are stated in that advance medical directive when and if you become disabled to the point you can't make those decisions for yourself. I hope that answers your question.
I think that was an excellent response
Mhm.
to let people know that estate planning is important. The reason why the surrogate put this on is because we know at times that people are unable to put a estate plan together. For instance, if there's a child who is getting ready to turn 18, he or she doesn't have the capacity to do estate planning. So adult guardianship will come into play with that. And the truth be told, given this unprecedented era that we're in, people just haven't had a chance to do estate planning. So that's why we also wanted to make sure that people were aware of what adult guardianship was about. Because if there is no plan, no durable power of attorney, no advance directive, then somebody is going to have to be appointed. And adult guardianship is the process, legal action that you have to take. And so, what I like to do with that is to also kind of and we kind of talked about it, but do a scenario a little bit different. Let's say you have a family member, let's say grandma, did not have a plan, and we know that she may have some form of dementia, no longer can take care of herself, and she doesn't have the plan in place. She has a home, um, and what happens to the home when what happens to the home once the individual what happens to the home if nobody's appointed guardian. Can anybody sell the house? There's no plan or anything in place.
So this happens far too often, right?
Mhm.
And the other thing that's a reality, unfortunate but real, and it happens over and over, you know, people get stupid when there's two pennies involved. And family members often do things that are unfortunate.
Yeah.
So having a plan in place is important. But here, grandma gets ill. Well, hopefully, someone could come in and start the process to have her taken care of. Make sure she receives the medical attention she needs, but also, how are we going to get that money in the bank to pay her property taxes, which were due on May 1st and I haven't yet paid? How are we going to do that? Well, the guardianship process has to be started unless there's a durable power of attorney. And let's say we decide she can't live at home anymore, and we're going to move her in to our extra room, or we're going to have to put her in a nursing home. And now we have this house. Let's sell the house. Well, let's say you've been appointed guardian. The court is, as I said earlier, the court is uh, uh, primarily responsible. So not even the guardian can sell the house unless the court gives approval.
Yeah.
In order to sell the house, you'd have to bring an action in the court. You'd have to show the court that the amount you want to sell the house for is a fair amount, which means you might have to get an appraisal. And you'd have to give notice to all interested parties. So maybe interested family members. And why do we do this? Well, we want to make sure that no one is trying to pull a fast one. And we want to make sure that the house, which is where most of us who have homes have our savings, right? That's where most of our money is. is protected for the incapacitated person. That money should be there to provide for their care. So, in order to sell it, if there's a guardian, the guardian has to bring an action to the court and get the court's permission. If there is no guardian, no one can sign that deed legally on behalf of the incapacitated person. Now, sometimes we may have some, that unscrupulous persons in the family or friends that try and do that. The court is available to prevent that from happening or to stop that. A person who doesn't know what they're doing should not be taken advantage of and be made to sign a deed when they don't know the effect of what their signature is doing. I hope that answers your question.
Yes, it does. I have a follow up, and I think I asked Tara this question. So, what does the court do to protect the ward of the court from the guardian running off with their money?
Who is the ward of the court? Explain the ward of the court, please.
So the ward of the court is the incapacitated person. So Tara, what happens when the court appoints a guardian? What does the court do to protect the incapacitated person from the guardian stealing the money?
The court appoints a guardian, and that guardian must file, reports, inventories, and if not timely, they will be notified by the AOC, who monitors these reports and makes sure everyone is in compliance. In some instances, the judge may require a bond to be submitted to the courts as part of your appointment. And in order for me to issue letters of guardianship, you must submit the bond per the court order in order to protect the interest of the incapacitated person, and that the person don't, do no strange things and abscond with the incapacitated person's.
So the bond, which is also called surety bond, is in essence an insurance policy to protect the ward, the incapacitated person's estate, just in case it's stolen. So if the guardian does something wrong, then a claim could be put against the bond, as opposed to having to go after that individual, the individual guardian. So the ward can get their money back from the bonding company, and bonding company then would be responsible for going after the guardian, correct?
Correct.
Thank you.
So, quick question. The guardian is responsible for paying for all those fees. Is that correct?
Which fees are you talking about? Are you talking about the $200 application fee?
So the fee for the application fee, any fees associated to this particular process, does that come from the estate, or does it come from the actual guardian themselves, or is there a budget that the Superior Court provides that provides some financial resources to pay for or supplement for the guardian, the assigned guardian?
So there is no budget, but as Tara mentioned earlier, there is a possibility of getting a fee waiver. You have to fill out the fee waiver request, which we did put a link in the comment section to do the fee waiver request. And if you meet the requirements, the Superior Court judge will instruct us, the Surrogate's Court, to waive the fee. But that fee comes initially out of the applicant's pocket, and then afterwards, that fee can be reimbursed later on if the judge allows it from the estate of the incapacitated person. But let's be honest. Most of the cases we see come through here, the applicant can't afford it. Most of the incapacitated people are on Social Security or some other form of governmental benefits. And so generally that money is going to be the responsibility of the applicant. They're going to eat that cost. That's generally what happens. But if there is money and the court allows it, then yes, it can be reimbursed to them, but the court will have to authorize that.
Yeah, this is one of
Thanks.
the few areas of the law where even an attorney who wants to charge his fee to the estate has to get permission of the court. Remember, once the court determines that this person is incapacitated, makes that person a ward of the court, the estate is under the supervision of the court. So any taxes, and I mean any charges against that estate have to be authorized by the court. Now, if there's a mortgage payment, the court isn't concerned as much about that. Each month, you have to report that yearly. But for legal fees, attorney fees, those have to be approved by the court.
And I just want to make one other point. As a guardian, you are what's called a fiduciary. So you are an agent, you are a super agent, that you are obligated to take care of that individual's affairs greater than you would take care of yours. And so if you do not do that, you can be sued for breach of fiduciary duty. So you have an obligation to do the best, the very best for that individual once you are appointed. And that's why the court requires you to do, annual reports and well-being, because, over the years, the courts have realized that there were people that were stealing from, let's be honest, whether it was their children or grandparents when they were guardians. So they put these monitoring programs in place to ensure that these things do not happen anymore.
Yeah.
Thank you. I know we're 7 minutes over our time that we allotted for this conversation, and I don't want to occupy too much of Charles' time, because I know he has a lot of work to do. But I want to thank you and thank everyone, for this conversation. Last question. I have one more last question, because I know I don't want to delay this elephant in the room thing in my head. COVID-19. What experience have you noticed in the last few weeks or few months as it relates to guardianship matters and COVID-19 and the emergent issue that are occurring where people can't have face-to-face conversation? What are things that you experienced, and what protections do you think people should have? And that's going to be my last question, and I want to leave from that point going forward.
So this nightmare of COVID, I don't think any of us were prepared for it. It does put a great stress on this area of the law where people need assistance. So the Supreme Court, which makes rules governing our courts, have come out with some emergency rules. Lawyers are permitted to conduct their investigations of alleged incapacitated persons over the telephone or over the video. And the court has continued throughout this COVID nightmare to hear guardianship cases. Now, they cannot hear cases that are contested. So, what does that mean? Where the alleged incapacitated person says, no, I don't want a guardian and I want a hearing, that person can say, I'll have a hearing over a video, a virtual hearing. But if they decide they want to be in court in person, those cases cannot proceed. And they are, and I have at least a couple of cases where that is the case. However, I've also had several cases where there's no contesting of guardianship. The alleged incapacitated person is not objecting, and those cases have proceeded. And we were concerned about how the process was going to proceed from the Superior Court through the Surrogates Court to get that order, which is issued by, I should say, not the order, but the letters of guardianship, which are issued by the Surrogates Court. But that's happening seamlessly, and that's proceeding without a hitch. So COVID has been a speed bump, but only in those cases that are contested. In other cases, we're proceeding. Look, if something happens to someone and they're driving on the highway and they get into a terrible accident and they fall into a coma and they need someone to act for them, there is still a process where a petition can be filed with the Surrogates Court, and an emergent temporary guardianship is possible. So the courts are still working to ensure that emergencies are dealt with, even during this nightmare of COVID. And thank you for that. And
No
if,
problem.
if I could just say, I don't know if you're going to have to take more questions, but I really want to thank the surrogate and the surrogate staff for reaching out, trying to explain some of these procedures to our Essex County neighbors. I've talked to folks who have gone to the surrogate's office, and to a person, they always tell me how courteous and helpful, really super helpful the staff is. And I want to thank the surrogate and staff for just being there and being so helpful to anyone who walks in that office. Often when folks come into the surrogate's office, it's because someone has died, it's because a guardianship is needed, it's because adoption is a question. So people come in there at emotional times in their life, and I just think it's so great that you guys have always treated people with great respect and have gone out of your way and continue to go out of your way to help folks. It makes a big difference. Thank you for that.
No, thank you very much. I have one last question. I know a young lady asked a question, and it relates to you. I have a 21-year-old son on the.
May do this. Make a suggestion. The one thing, I'm also an attorney, and looking at this question, there's privacy issues, so I don't want him to answer that question on his line. If Ms. Muhammad, if you can inbox the Essex County Surrogates Court, we will get that to Professor Afant, because the clinic is your attorney, and there's a attorney-client privilege, which I don't want them to, to break. So inbox us, and we'll get your information to him so he can reach out to you and respond to that, because that's a little bit too personal for us to do that on this form.
Got it. Thank you, DeVero. Appreciate you. Again, thank you, Charles, for participating in this conversation. Tara, thank you very much, for the information that you provided everyone, as well as the process and procedures. If you have any questions going forward and you need to get in contact with a Superior Court clerk, Tara is always available and accessible. And she's been doing this for years, and she knows exactly what she's doing because she's an expert in this space. So Tara, you want to share any last words?
Yes, and to contact me for right now under such circumstances, by email is sufficient. I respond to all my emails, and we're working with everyone diligently and efficiently as possible to keep the process flowing. And my email is twilson at surrogate.essexcountynj.org.
And what is your
And
telephone number?
stay safe. And my direct dial as well, 973-621-4907.
And my last thing I just want to say, right now we're open from 8:30 to 1 o'clock. During the pandemic, there is no public access, but you can call us. If you have a question related to this matter, call Tara. She gave you her information. If you have a general question about the probate clerk, call us at 973-621-4901 between the hours of 8:30 to 1. We're hoping, just like everybody else, this pandemic is over so we can, do what we do, serve the people, because this is important information that we gave you today, but what we do impacts everybody's lives, and we want to help people out. As the professor said, people come to us during some of the toughest time in their life, and we're here to help everybody, and we want to continue to do that. So give us a call if you need our help with any of these matters that we do. And thank you for listening in. Thank you.
And Professor, again, thank you for sacrificing your time and providing information to our residents who need, some sort of guidance regarding, such personal matters, and was able to talk to someone and to give them not only legal advice, but also, anecdotal advice in terms of just getting through this process. And so, I appreciate you availing yourself, and if you have, if you're able to come back again, to provide us more information, this is definitely open, web policy. And so we want to make sure that you always, have a friend in us, and you're always able to use our forum to make sure we can inform people.
Thank you. Thank you for asking.
And we'll type that information in for you, Ms. Muhammad.
Yep.
And to the audience, to people who shared this stream and also who participated, thank you for asking some great questions. We will leave this video up for future references. So if you want to go back to it and look for more information and some guidance, the forum will be on this Facebook page. We're trying to take the information and the content to put it onto our website, but we want to make sure that we have enough information to keep our residents informed as to what we do and how this court can be a service to you, and you're fully aware of what to do when matters, personal. Next week we're having a conversation about adoptions, and to talk about adoptions. So if you have any questions leading up to next week, please inbox us direct questions. Join our conversation surrounding adoptions. It's going to be a fun conversation, and we definitely want you to participate. If you have any questions or considering adopting, or maybe just inquiring, just join our conversation next week. Thank you, everyone. Take care.
All right, take care. Stay safe.
Bye-bye.